This conference will now be recorded.
Hello, and welcome to the presentation on Workers' Compensation 101. This presentation is being done on behalf of RTGR Law. RTGR is a statewide firm dedicated to defending public agencies. We represent several of California's cities, counties, fire districts, ports, and other public entities in complex workers' compensation claims and appeals, disability accommodations and interactive process, fraud prevention and prosecution, and public safety officer benefits and retirement. My name is Sarah Bushman, and I'm an associate attorney with RTGR.
This conference will now be recorded. This conference will now be recorded.
Hello, and welcome to the presentation on Workers' Compensation 101 presented by RTGR Law. My name is Sarah Bushman, and I am an associate attorney with RTGR. RTGR is a statewide firm dedicated to defending public agencies. RTGR represents several of California's cities, counties, fire districts, ports, and other public agencies in complex workers' compensation claims and appeals, disability accommodations and interactive process, fraud prevention and prosecution, public safety officer benefits and retirement. Today, we're going to be discussing a background of workers' comp and some of the basics that you should know about workers' compensation. As I previously stated, my name is Sarah Bushman, and I represent several public agencies and employers throughout Northern California. I've litigated several claims, won trials on temporary disability issues, entitlement, and AOE/COE issues, permanent disability determinations. I also counsel clients on complex issues such as AOE/COE, the entitlement, or the
This conference will now be recorded. This conference will now be recorded.
Hello, and welcome to the presentation on Workers' Compensation 101 presented by RTGR Law. My name is Sarah Bushman, and I'm an associate with RTGR Law. RTGR is a statewide firm dedicated to defending public agencies. We represent several of California's cities, counties, fire districts, ports, and other public agencies in complex workers' compensation claims. Some of those claims involve appeals, disability accommodations, and the interactive process, fraud prevention and prosecution, and public safety officer benefits and retirement. Today, we're going to be discussing some of the basics of Workers' Compensation 101 that everyone should know and some of the history behind workers' compensation law. As I previously stated, my name is Sarah Bushman. I represent several public agencies and employers throughout Northern California. I've litigated numerous claims, won trials, and handled appeals. I've gone to trial over issues such as AOE/COE, entitlement to temporary disability, and permanent disability disputes. I also counsel clients on complex issues such as AOE/COE, the entitlement to Labor Code Section 4850 benefits, safety officer presumptions, and IDRs. If you have any questions during this program or after this program, feel free to contact me directly at Sarah, S-A-R-A, at rtgrlaw.com, or feel free to contact any of our other offices throughout California. As a disclaimer before we get started, the information contained in this presentation and provided by RTGR Law is purely for educational and informational purposes. It should not be construed as legal advice on any subject matter, and it should not constitute legal advice. Feel free to reach out to us, like I said, though, if you have any questions or concerns, or if you need assistance, any further assistance with any legal matters. If you have any questions during or after the program, as I previously stated, feel free to contact any of our offices located throughout California, or feel free to contact me directly again at SARA@rtgrlaw.com. So what is workers' compensation benefits? It's a system of workplace injury laws that originated in Germany in the 19th century and then came to the US in 1911. These laws provide for medical care and compensation to injured workers on a no-fault basis. What this means is that regardless of how safe an employer may try to make its workplace, on-the-job accidents and job-related illnesses will occur no matter what. There's also workers' compensation programs covering federal employees, longshoremen, merchant seamen, railroad employees, and coal miners, to name a few. Workers' compensation is mandated by law in all 50 states, including the District of Columbia, Puerto Rico, and the Virgin Islands. Workers' compensation has become increasingly complicated and costly over the years, mainly because of the types of claims that are being brought, the law involved in them, such as presumption for certain cases. Therefore, it's essential as managers and supervisors, in addition to human resource staff, to know how to comply with these laws, especially because of the ever-changing nature of workers' compensation as well. New laws get enacted, new Senate bills get enacted every single year, and you need to be on top of these laws in order to make sure that you're appropriately complying with them. This particular session will provide you with knowledge of workers' compensation laws and workplace safety rules so that your employees receive the full and correct benefit of the law and that you keep on-the-job injuries and costs as low as possible. So what is the purpose of workers' compensation benefits? The law provides that coverage of medical expenses for treatment or injuries of occupational illnesses, income protection for employees who must be absent from work because of occupational illness or injury in the form of temporary disability, or depending on if it's temporary partial disability or temporary total disability, limited compensation for serious permanent injuries such as loss of limb or loss of life. These laws also contain anti-retaliation provisions, which means that you cannot retaliate against an employee because they have filed a claim or received benefits under the law. There are three methods by which an employer can ensure workers' compensation benefits: through an improved private compensation insurance carrier, through self-insurance. This is only the option for employers that have the financial resources to provide workers' compensation benefits in good and bad times. There must be a guarantee that the injured employee will not lose his or her benefits in the event of bankruptcy of the employer. And then the third method is through state-funded insurance. There's some advantages for employers and employees with having workers' compensation. For the employers, employees cannot seek damages through a separate tort suit against the employer because workers' compensation is an exclusive remedy for on-the-job injuries, meaning that once they receive those benefits, they cannot get any other benefits through another remedy, such as a tort suit. Employees are limited as to the amount of benefits that they can recover. So it's not some endless system where they can just keep receiving. There's certain limitations and laws in place regarding what they can receive and how much they can receive. For employees, on the other hand, there are certain advantages, such as coverage is provided without direct cost to the employee. This isn't something that's put into their paycheck. Employees receive prompt payment of claims following an injury. Medical expenses are compensated, and payments are based on employees' current earnings and are generally excluded from gross income for tax purposes. Payments are made to an employee's spouse or dependent children in the event of a death. As I was stating earlier, workers' compensation is an exclusive remedy for those injured or killed on the job. Generally, employees cannot sue their employer for damages in civil court, and this is governed by Labor Code Section 3602A. However, this exclusivity can be waived and the employee can sue in court for damages in very certain circumstances. These include if the injury results from certain types of intentional or egregious conduct, or when the employer does not have workers' compensation coverage or permissible self-insurance. In the state of California, as in many other states, workers' compensation insurance is mandated. Therefore, it's extremely important to have insurance or to have permissible self-insurance so that the injured worker cannot sue for damages in another type of court. Under California workers' compensation, plaintiffs can recover, or the injured worker can recover, punitive damages, damages related to loss of any pain and suffering, and loss of consortium, which is loss of the personal relationship with your spouse. There are also several disadvantages to the workers' comp system for employers and employees. Employers, there may be premiums that are high because of the nature of the employer's business, meaning that there are just more individuals that could potentially be injured. Therefore, costs are associated on employers' accident record. So if it's a type of business where employees are frequently being injured or it's common to be injured, then the premiums can be a lot higher to the employer who has to bear that burden. Employers' paperwork burden is increased because of requirements to file accidents with state authorities and also providing forms to individuals such as DWC-1s. Employers may spend time defending fraudulent or spurious claims. Even though a claim may be fraudulent, there does still need to be some type of defense and investigation into the facts that they're fraudulent. Then it can be referred over to the district attorney's office. But oftentimes, even if the claim is fraudulent, there has to be some background work done at a cost to the employer. There are some disadvantages for the employee, such as employees are denied an opportunity to seek damages beyond the workers' compensation, such as pain and suffering or punitive damages through a tort action against the employer, which could amount in a much larger sum to the employee as compared to the workers' comp system. In some state, workers' compensation benefits may be offset by Social Security disability benefits. When there are multiple employers that are involved in an injury, joint employment occurs in California when there's a cumulative trauma, meaning that the injury spanned over the course of years, or successive injuries. That applies to both specific or cumulative trauma when all injuries contributed to the need for medical treatment. So in the successive injuries, what that means is there was a specific injury, and then another specific injury, and then another specific injury. And there's a doctor opining that all three of these specific injuries led to the current need for medical treatment. Then there would be a joint employment issue where all employers need to be held accountable for their role or their contribution to this individual's injury or need for medical treatment. A party may join other parties that it believes share an exposure of workers' compensation claims and benefits. And this is found in California Code Regulations, Title 8, Section 10380. Any employer who's found to be liable for any injury that it believes other employers may share an exposure must start proceedings within 1 year of the award from the Workers' Compensation Appeal Board to determine the apportionment of liability. So like I was stating earlier, when you have 3 separate specific injuries, let's say on the third specific injury, that individual has been working for employer B, but employer A, they'd been working for when the 2 prior specific injuries had occurred. And a doctor stated, well, these 2 prior specific injuries from employer A contributed 50% to the injury we are now dealing with employer B. The employer B would be able to seek contribution and join employer A in order to not bear the full burden of the workers' compensation benefits that are going to be due to this individual. With joint employer status, California workers' compensation law determines liability in a joint employment scenario based on specific periods of workers' employment with any given employer. So what that means is that for specific injuries, an employee must have been employed by the employer when they sustained one or multiple injuries that contributed to the need for medical treatment. So the previous example with employer A and employer B. Employer A, if that person only worked for employer A for a year, had these 2 injuries, but then worked for employer B for 6 years, you're going to have different contributions of liability. And this depends, usually in these types of situations, when I've had contribution cases, I'll try to get a qualified medical evaluator or an agreed medical evaluator to state specifically what percentage of the injury do you attribute to employer A and employer B, given the work requirements, job duties, the injury, the specifics of that injury, what do you attribute to each employer, and therefore, how would we break down liability amongst the employers? When you first find out that an employee has been injured, there's an initial plan of action that should be taken for all employers. First, you must acknowledge the claim. You must provide a DWC-1 to the applicant, which is also partially part of step 3. But you must acknowledge the claim. You must speak with the individual, and this can also come through constructive knowledge, meaning someone else mentions to you, hey, so-and-so has an injury. You still must acknowledge that claim. Step 2 is to provide direct employee to medical treatment. So you must tell the employee, you have an entitlement to medical treatment. This is where you should be going. Step 3 is taking care of paperwork, such as an employer's initial report, DWC-1, things of that nature. Step 4 is to consider subrogation, which are third-party claims, meaning, did this injury occur as a result of another individual? So when acknowledging the claim, Labor Code Section 5402 states that knowledge of an injury obtained from any source, like I said, it could be from another person, not the specific employee, on the part of the employer, his or her managing agent, superintendent, foreman, or other person in authority or knowledge of the assertion of a claim of injury, sufficient to afford opportunity to the employer to make an investigation into the facts, is equivalent to service of a written notice of injury. Direct medical treatment, if it is an emergency, you should call 911 or direct the employee to the nearest emergency room. For non-emergency injuries, promptly provide first aid if needed, and direct the employee to the designated medical provider specified through your workers' compensation program or insurance provider. Some employers have medical provider networks or MPN. If an MPN is in effect, the employee can go to any provider in that network. If there is no MPM, the employer or the insurance company has first 30 days to control over medical provider used. After those 30 days, the employee can then choose who they'd like for their medical provider. If the employee has pre-designated a doctor, contact your insurer, broker, TPA, or attorney for advice. Step 3, which is taking care of paperwork, like I stated previously, provide the claim form to the employee, the DWC-1. Report the claim to your TPA or insurance carrier, complete the employer's report of occupational injury or illness, and report to Cal OSHA of any serious injury or illness or death. And then, as I was stating previously, step 4 is to consider subrogation. Was the injury someone else's fault? Was there a third party, not the employer or the coworker? For instance, you have an employee and they're in their truck that's been given to them through their work, and they're driving along, and a third party is not paying attention, runs a stop sign, T-bones them, hits them because they were texting. There's a police report that says the third party was at fault. There's witnesses that say that the third party was at fault. This is all great evidence. You can then have a subrogation claim for your employee who, let's say that they sustained whiplash and a low back injury as a result of this car accident. You still have to provide them with medical support. You still have to provide them with the DWC-1. You still have to go through the typical steps of a workers' compensation claim where there's no subrogation. But in a subrogation claim, what's great is that at any point when there's either been settlement or prior to settlement, you can go after that third party and their insurance. So in this case, their car insurance. And you can have them supplement benefits to your injured employee or have them provide contribution for any benefits that you may have provided to your employee. So as I was stating, the work injury claim still pays, but you may get reimbursement. You should notify your TPA or insurance right away and save any evidence, like contacting info from the witnesses, any physical evidence. Police reports, as I stated, are a great way to get this type of evidence when the police have actually been contacted or involved, such as with a car accident. So when you first have a claim for workers' compensation, and you're trying to defend against it, the first thing you should be thinking of is AOE-COE. This means arising out of it in the course of employment. In order for a workers' compensation claim to be compensable, it must arise out of and in the course of employment. There are also some other defenses that we're going to be discussing and some presumptions of injury that we're going to be going through as well. So as I was stating, AOE-COE, arising out of it in the course of employment. Workers' compensation laws contain an average formula stating that to be compensable, an injury must arise out of, meaning cause and origin of injury, and in the course of employment, referring to the time, place, and circumstances of the injury. Generally, the burden of proof starts with the employee to prove this with some medical evidence. There's then the coming and going rule. So this can be something that you need to keep in consideration when determining whether or not an injury arose out of it in the course of employment. Going to and from work, the general rule is that an employee is not covered during their normal commute to and from a fixed place of work. However, and this is included when the employee is on the employer's premises, such as a parking lot, but is not yet started or is left for the day or is running a special errand for the employer. So if the employee is required to run a special errand for the employer, then this coming and going rule may apply. Make sure to always reach out to your attorney to find out if this coming and going rule can apply in certain circumstances. There's other defenses that should also be considered. There's the employment independent contractor, voluntary intoxication, self-inflicted injuries or suicide, initial physical aggressor, off-duty recreational activity, post-termination cases, and site claim defenses. So there are some injuries that are considered presumptive. Any claimed injury is presumed by law to be compensable if the employer fails to timely deny the claim in writing within 90 days of the knowledge of injury. Now, you also can delay the claim. There's three things that can be done when a claim first comes in. It can be accepted, delayed, or denied. If the claim is accepted, great. You move forward, you provide them with benefits. If they're off work, they get temporary disability. If they're found permanent and stationary and there's a rating, they get permanent disability. Great. You can delay the claim, meaning that you need more time to investigate the claim, or you can deny the claim. However, this acceptance, delay, or denial must be done within 90 days of knowledge of the injury. There are also certain safety officers' claims that are presumed compensable, and that's if they involve cancer, heart trouble, hernia, pneumonia, low back due to the duty belt, and there's a few others. We actually have another presentation that's been done on presumptions of injury, so feel free to take a look at our website and find that specific presentation if you're interested on those particular presumptions. So there's certain things that are done in order when a workers' comp claim is being handled. There's workers' compensation benefits, the court system, return to work, and there's ways to reduce claims. So here's an overview of California workers' compensation benefits. Usually when an employee is injured, they're entitled to medical care. If they're off work and the claim has been accepted and they're off work as a result of that injury, they're entitled to temporary disability. If the employee is off work and has been found to be permanent and stationary and there's a rating for their injury, they're entitled to permanent disability. If the injured worker loses their job, they may be entitled to a supplemental job displacement benefit or voucher. And there's also the administrative court system and processes. So medical care. Treatment is provided and subject to utilization review and independent medical review, meaning that when a doctor submits a request for authorization for certain medical treatments, this is then provided to UR, who then makes an independent decision about whether or not this treatment should be approved. If this treatment is denied and that individual or that individual's attorney disagrees with that decision, they can then submit that UR decision for independent medical review through IMR. Medical care also includes reimbursement for reasonable travel costs and includes a provision for an interpreter if needed. Temporary disability is found when a doctor provides a work status and the employee is off work or with restrictions. So you can have two different types of temporary disability. You can have temporary partial disability or wage loss, or temporary total disability. So if an applicant is found to be temporarily total disabled and they're off work, or the employer can't provide modified duty, temporary total disability is paid, which is 2/3 of their average weekly wage tax-free. And this is subject to a maximum rate. However, if the applicant or the injured worker is temporarily partially disabled, meaning that they can still work with restrictions and those restrictions can be accommodated, but they won't be earning as much of a wage as they were previously, then that wage loss is what's accounted for. So in lieu of temporary disability, certain public safety officers receive their full salary up to 52 weeks, and this is found in Labor Code Section 4850. And this is their full salary untaxed. I forgot to mention, temporary disability also has a cap of 104 weeks, and also there's a statute of limitations on receiving temporary disability, which is 5 years from the date of injury. Permanent disability kicks in once an individual has reached maximum medical improvement, and this is based on their level of impairment. Doctors will provide a whole person impairment rating within the AMA guides that then is adjusted for their age, occupation, and the body part that's injured. And this permanent disability is generally based on objective findings, such as their gait or their range of motion, things like that. A doctor is required to explain that in their report in order for their report to qualify as substantial medical evidence. Once that number is determined, that individual is then given permanent disability at a weekly rate. They may be able to return to full duty, but can still have permanent disability. The supplemental job displacement voucher or benefit is if there is permanent disability, an employee is entitled to a $6,000 voucher for vocational training expenses unless the employer offers return to work. There's specific forms that have to be used in order to return to work, and the location, duration, and wage requirements for an offer to take place of the voucher. And this is addressed in conjunction with the interactive process. So sitting down and having conversations and meetings with the injured employee in order to determine whether or not they're entitled to a supplemental job displacement benefit or voucher. And if you have any questions about whether or not someone is entitled to the voucher, you should always reach out to your attorney. There's also the court system. And through the court system with workers' compensation claims and injuries, we have the Workers' Compensation Appeal Board. They are all throughout California. These are administrative law judges, and when there's a trial that's held, there's no jury. Instead, it's just defense counsel, counsel for the applicant, if there is counsel involved, any witnesses that may need to be present, the judge, and then a court reporter. All settlements must be approved by a judge. All cases are initiated by filing an application or settlement. The case must be filed before compelling discovery, which means that there must be an application. Claims are not necessarily filed as cases at the WCAB. So even though an application may be filed, this isn't necessarily a case that goes to the I misspoke. Claims, when the claim is filed, the DWC1, this is not necessarily filed as a case with the WCAB. Not until an application has been filed does it then become a case at the WCAB. So now I'm going to discuss return to work, employer opportunities and responsibilities. You can offer temporary modified work, meaning there's been work restrictions that have been given by a doctor to the injured employee, and you can offer modified work on a temporary basis, or the work restrictions are only temporary, so they only need this modified work on a temporary basis. Or you can offer permanent modified work, meaning the work restrictions that have been given are on a permanent basis. They won't be changing, regardless of how much medical care they may receive or surgeries they may undergo. These restrictions are permanent, and then you can offer a permanent modified job. Or the impairment from a work injury claim belongs in the interactive process, like all other impairments, meaning you have discussions with the employee, the injured worker. You sit down and you talk to them about, your doctor provided that you can't lift more than 20 pounds. Do you feel that you can lift more than 20 pounds? Having a conversation with them about whether or not they feel they're capable of working within these work restrictions, or if they believe that they should have more work restrictions or less work restrictions. Temporary modified work can be provided on a full-time or part-time basis. If the modified position pays less, hours or pay rate, temporary disability wage loss will make up the difference. So that's temporary total disability, as I was discussing previously. Reducing temporary disability costs to the claim when offering temporary modified work. So if you're offering temporary modified work and they're only getting the temporary partial disability, then this can reduce the overall temporary disability cost to a claim. Studies show that less time off work, there's typically a better outcome in the long run with a workers' comp claim, and you should treat employees with respect and provide meaningful work. Permanent modified work happens at the point when someone has reached maximum medical improvement, so there's no further temporary disability, even if return to work is not offered. because at the point that someone's considered permanent and stationary or has reached maximum medical improvement, this is when permanent disability kicks in. So if there is permanent disability and no appropriate return to work, then a supplemental job displacement voucher is due. The employer has interactive process obligations independent of the workers' compensation system. So there's an impact of the work injury claim on the interactive process. A claim should provide work status information. The employer and the employee can and should have direct contact. Don't just rely on a claims administrator. Claims administrators should move forward with the physician's return to work and voucher report to the employer. That there should be constant communication between not only the employee, employer, and the claims administrator, but all three individuals together. Claims administrator can help get clarification on work restrictions from the doctor if needed. And this is really helpful, especially when there are job duties that have been specified. And so providing the doctor with those job duties so that they can opine on whether or not the applicant can return to them in light of the restrictions. There's ways to reduce workers' compensation injuries and claims. Develop and implement an employee safety culture. Establish and empower a safety management committee that's in charge of your accident prevention program, and educate managers about the cost and impact of workers' compensation and hold them accountable for prevention of injuries. Here are some more ways that you can reduce workers' compensation injuries and claims. You should always report workers' compensation injuries as soon as possible and decide on appropriate steps to take to prevent similar injuries. A lot of times I've seen reports where an employee is injured, and then within that report, it's not only the first reporting of it, but also there's a discussion with the employee about how could this have been mitigated in the future? How is this something that we can avoid in the future? You should also have a light duty return to work program because, as I stated previously, studies have shown that returning to work or being back at work and not being off work helps overall. Maintain frequent contact with the injured employee and the workers' compensation case manager. Use other resources such as an EAP and workplace wellness. Thank you so much for your time today. If you have any questions regarding this presentation or any of our other presentations, feel free to contact any of our local offices or contact me directly at Sarah, S-A-R-A, at rtgrlaw.com. At RTGR Law, we not only deal with workers' compensation claims, but we can also help you with your civil subrogation claims or any employment law issues that you may have. I appreciate your time today, and I hope that you have a great day. Thank you.